Picture this, you've built a fortune, your business, your investments, your legacy, but one lawsuit, one aggressive creditor could wipe it all out, or could it? What if I told you there's a way to shield your wealth immediately like flipping a switch and make it nearly impossible for creditors to touch no matter how hard they try? That's not a dream, that's a Cook Islands trust. And today I'm pulling back the curtain on why it's the ultimate lawsuit kryptonite. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've been in the asset protection game. And for nearly 3 decades, I've been setting up Cook Islands trusts more than any firm in the world. At Asset Protection Planners, we've helped thousands of high net worth individuals lock their wealth in a fortress that creditors can't breach. And today I'm diving deep into how a Cook Islands trust protects your assets the moment you fund it, why creditors face a ticking clock to even try, and how our unique structure makes you the master of your wealth while keeping it untouchable. So stick with me and I'll show you why this is the gold standard of asset protection. I know if you find this no-nonsense, high-value insight helpful, hit that subscribe button if you haven't. We drop videos like this regularly to help you protect what you've worked so hard to build. Let's get started. Here's the first thing that you need to know. A Cook Islands trust doesn't mess around. The moment you transfer assets into a properly structured Cook Islands trust, they're protected. Not in a year, not after some legal waiting period, right now. Now, I'm going to address the statute of limitations thing in a bit and explain how it works, so hold on for that. Protecting assets right away isn't like domestic trusts in the US, where creditors might still claw at your assets for years under fraudulent transfer laws. In the Cook Islands, the jurisdictional independence and ironclad laws create a wall that creditors frankly can't scale. Why? The Cook Islands operate outside of the reach of U.S. courts, or any foreign court for that matter. Their International Trust Act, passed in 1984, is designed to prioritize asset protection. I mean, after all, their economy depends on their offshore financial services industry. So once your assets are in the trust, they're governed by Cook Islands law, not your home country's law. So that's a game changer. It's like moving your wealth into a legal fortress on a tropical island, minus the palm trees in your backyard. So let me give you a real-world example. A client of ours, let's call him Dr. Jones, was a successful surgeon with a thriving practice. So one malpractice lawsuit threatened to unravel everything. So he came to us in a panic, worried that a single judgment could take his savings, his real estate, and even his kids' college funds. So we set up a Cook Islands trust, transfer his assets, and within days, his wealth was shielded. When the lawsuit hit, the plaintiff's lawyer tried to chase his assets, but they hit a brick wall. The Cook Islands courts didn't care about the U.S. judgment. Dr. Jones' wealth was safe, and he slept easy knowing his family's future was secure. So that's the power of immediate protection. No waiting, no loopholes, just peace of mind. Okay, now let's talk about the part that makes creditors sweat, the ticking clock. Under Section 13B of the Cook Islands International Trust Act, a creditor has a very short window to challenge the transfer into a Cook Islands trust. Here's how it works. They have 1 year from the date the trust was created and funded, or 2 years from the date of the cause of action, whichever comes later. After that, it's game over. The Cook Islands courts will dismiss the case outright, no matter how strong the creditors think their claim is. So this is what I call the 1-2 punch of asset protection. So let's break it down with a hypothetical. Let's say you're a real estate and stock market investor. You transfer $5 million in properties and cash into a Cook Islands trust. We had used additional tools for properties we'll talk about later. And let's say you set up that trust in January of 2025. In June 2025, the tenant sues you, claiming they slipped on your property back in 2024. They win a judgment in 2026 and they come after your assets. So here's the math. The trust was funded in January 2025. So that 1 year window for a fraudulent transfer claim ends in January 2026. So the cause of action, the slip and fall, happened in 2024. So the 2 year window from the cause of action ends in 2026. Since the 1 year from transfer rule is later, the creditor has until January of 2026 to file the claim. Missed that deadline? Too bad. The Cook Islands court won't even hear the case. And here's the kicker. Even if they do file within that time window, we've never seen them win. Why? Because the creditor has to prove a case beyond a reasonable doubt, which is a criminal law standard that you set up the trust with the sole intent to defraud them. And that's a nearly impossible bar to clear, especially when you work with a firm like ours that ensures your trust is structured properly and transparently. So you might be thinking, business guy, has a creditor ever actually broken through a Cook Islands trust? Good question. In nearly 30 years of setting up trusts like I have, more than any firm in the world, I can tell you when the trust is set up correctly with no fraud or concealment, like if somebody stole money, it wouldn't protect them then. But of course, we don't take clients like that, so it's never happened to us. Creditors don't win. They've never won, period. There's no known case where a creditor has successfully penetrated a properly structured Cook Islands trust in a fraudulent transfer challenge. Never. So let's look at a famous example, the Anderson case from the 1990s. In fact, I talked with the Andersons before they passed away. A U.S. couple, the Andersons, set up a Cook Islands trust to protect their assets. When they faced a massive lawsuit in the U.S., the plaintiffs tried to go after the trust. They hired top lawyers, flew to the Cook Islands, and they threw everything they had at it. The result? The Cook Islands court shut them down. The trust held firm and the Andersons' assets were untouchable. So why do creditors keep losing? 3 reasons, really. Number 1, jurisdictional independence. Cook Islands courts don't recognize foreign judgments. A U.S. court ruling really means nothing there. Number 2, high burden of proof. Proving fraudulent intent beyond a reasonable doubt is a legal Everest. Most creditors don't even try. Next, short statute of limitations. That 1 to 2 year window I mentioned, it's really a death knell for most claims. So this isn't just theory. At Lawyers Limited, our law firm, we've seen this play out time and time again. Another client, a tech entrepreneur, we'll call her Sarah, faced a $10 million lawsuit from a former business partner. Her Cook Islands trust, set up years earlier, held her stock portfolio and real estate. The partner's lawsuits tried to challenge the transfer, but they missed the 2-year window. The case tossed out before it even started. So Sarah didn't lose a dime. For the real estate, by the way, we also record equity stripping liens, and we get third-party lenders involved, so there's some extra steps if it's real estate. So that's why I call it lawsuit kryptonite. It doesn't just delay creditors, it stops them altogether. So here's how it works, and here's why it's a genius move. When you set up your trust with us, we create a Cook Islands LLC, owned by the trust. We transfer your assets, cash, real estate, stock, you name it, into the LLC. And like I said, real estate requires additional strategies such as equity stripping, land trust, domestic LLCs that we discuss in other videos. And then we make you the manager of that LLC. This means you retain control over your assets. So in other words, you can buy, sell, invest, or manage them as you see fit, just like I do in my Cook Islands Trust, trade stock, and so on. So you can manage your assets just about like you always have. But here's the magic. If a lawsuit strikes, our licensed bonded trustee company law firm in the Cook Islands steps in. They take over as manager of the LLC, locking the assets inside of the trust protective shield. Creditors can't touch them because the assets are no longer under your direct control. They're governed by the trust and Cook Islands law. So think of it like a bank vault. You have the key, manage your wealth day to day, but when a thief, aka creditor, shows up, the vault slams shut, and only your trusted law firm holds the combination, and you can get your money anytime. So let me share a story. A client, let's call him Mike, was a real estate developer with $20 million in properties. He loved the idea of asset protection, but didn't want to lose control of his investments. We set up a Cook Islands trust with an LLC inside. We made Mike the manager and encumbered his properties with the LLC and equity stripping liens. 2 years later, a contractor sued him for $5 million. When the lawsuit hit, our Cook Islands trustee stepped in, took over as manager. We got third-party lenders to purchase the mortgages, and these were the mortgages we already had in place. We put the proceeds of those mortgages in the trust, and the assets were untouchable. Mike still had his wealth, his control once the lawsuit was resolved, and his peace of mind. So this structure is why our clients trust us. You get the best of both worlds, control and protection. So want to learn more about how we set this up? You can go ahead and head over to assetprotectionplanners.com for a free consultation, or just look at, get free information there, whatever you like. If you're serious, you can reach out to us. So by now you're probably thinking, sounds amazing, but how do I get started? So I've got you covered with 3 actionable steps to protect your wealth with a Cook Islands Trust. Number 1, assess your risk. So take stock of your assets and your exposure. Are you a doctor, entrepreneur, real estate investor? You have significant wealth in stocks, property, or businesses. High net worth individuals are really lawsuit magnets. So the sooner that you act, the better. So step 2, work with the best. Not all people who talk about asset protection are created equal. You need a firm with experience, somebody who set up more Cook Islands Trust than anybody else. And there's only one of them, that's us. At Lawyers Limited, we've been doing this, or I've personally been doing this for 34 years. And with nearly 3 decades of Cook Islands Trust expertise, we're not experimenting with your wealth, we're perfecting it. Okay, next, number 3, step 3, act before the storm hits. The biggest mistake I see, waiting until a lawsuit hits to set up a trust. Once you're sued, it's harder to transfer assets without raising red flags. If it's a divorce, we won't even touch the case because there are freezing orders in place. There's financial restraining orders preventing us from helping move your assets into the trust. So you have to act quickly. With a lawsuit, we can act after the fact, but it's going to be a lot more expensive for you, and it's going to be a lot more difficult to protect, though we can do it. So the key thing is set up your trust now when the skies are clear. The moment it's funded, your assets are protected, and here's a pro tip. Don't try to hide assets or set up a trust with the intent to defraud creditors. Act early and work with us to structure everything transparently and legally. We'll ensure your trust is ironclad and compliant with Cook Islands laws and are protected from anything that attacks you in the country where you live, the US, Canada, Australia, New Zealand, wherever you live. Okay, now before we wrap this up, let's bust a few myths about the Cook Islands Trust that might be holding you back. Myth number 1, it's too complicated. Wrong. Setting up a Cook Islands Trust with us is really straightforward. We handle all the paperwork, the legal structure, and the trustee setup. You just tell us what your goals are, and we make it happen. Myth number 2, you lose control of your assets. Not with our LLC structure. As the manager of the LLC, you call the shots until the lawsuit hits when our trusted company steps in to protect you. So it's control with a safety net. I mean, after all, if you have control, you don't really have control. The judge has control. So when you lose a lawsuit, you get a judgment against you. Whatever you have control to do, the judge now can force you to do that thing against your will. So that's the reason why our trustee company law firm can run interference for you and still protect your money. And they have a decades track record of integrity and honesty and treating people properly. We've never ever seen anything not carried out with integrity with our Cook Islands trustee. It's really the most regulated trust industry in the world. Next myth we hear, it's only for billionaires. Not true. While we work with ultra high net worth clients, Cook Islands Trust are ideal with anybody with significant assets. Think $1 million and up. So if you got a business, real estate, or hefty portfolio, this is for you. So here's the bottom line. A Cook Islands Trust isn't just a tool, it's a fortress. The moment you fund it, your assets are protected. Creditors have a tiny 1 to 2 year window to even try, and history shows they consistently lose. So you keep control of your wealth while knowing it's untouchable when it counts. And for 34 years, I've been in the game helping high net worth clients like you safeguard their legacies. At Lawyers Limited, we've set up more Cook Islands Trust than any firm in the world, and we're ready to help you. If you need it, head on over to assetprotectionplanners.com. Lots of free info, free consultation. So let's build your financial fortress today. So if you found this video valuable, give it a thumbs up, share it with somebody who needs it, and subscribe for more insights if you haven't on protecting and building your wealth. So this is The Business Guy, and we'll see you in the next one.